And now for something completely different.
Forget everything you've been told by others before. Get ready for the real deal, the full story. Real talk about money, markets, life. Now, it's The Real Investment Show with Lance Roberts, presented by RIA Advisors.
And good morning and welcome to the Tuesday edition of The Real Investment Show. Of course, Jon Penn joins me today. We're going to be talking a little bit about the matter of trust. We're going to talk a little bit about trust and estates. We started this conversation last week, got a lot of questions about it, so we're going to flesh that out a little bit more this morning. So we'll get to that in just a second. Also, of course, it's Tuesday, and I do love the smell of napalm in the mornings. Robert Duvall passed away over the weekend at the ripe old age of 95. Of course, that line, one of his famous lines from Apocalypse Now. If you have not seen that movie, well worth the watch. For you younger kids out there, go watch Apocalypse Now. But yeah, so guy's done just a long history of movies of every type, from Days of Thunder to Apocalypse Now. I mean, just the whole gamut. He was one of my favorite actors of all time. I've watched everything that probably Robert Duvall's in, been twice. So, but anyway, lived a long life. Lived 95 years old, passed away over the weekend. So, condolences to the family. But again, he will be missed. Outside of that, it was kind of a nonchalant weekend for the most part. Of course, yesterday markets were closed for President's Day. So today will be the first trading day of the week. And of course, it'll be a holiday short. I mean, because of the holiday yesterday, it'll be a short trading week on top of that. So we'll kind of see how markets go this morning. Futures pointing a little bit lower this morning, not anything drastic. We've seen mornings like this where we kind of recover out of the gates, but we'll see. Markets have been under pressure as of late. Again, we've been going through this kind of rotation within the markets as well. So again, it's kind of interesting. If you take a look at the market cap weighted index, it's about flat for the year. The equal weighted index is doing very well this year. So again, quite the difference from what we've seen in previous years in terms of how the index is playing out. You've got this very big bifurcation. Yesterday's article on the website goes through the sectors of the S&P 500. And you can see this very big bifurcation in the markets. Energy's doing well. Basic materials, industrials, they are trading at very, very extended extremes. They're very overbought on multiple levels. And yet then on the other side, almost an immediate divergence, you've got technology and other areas, discretionary communications, trading very oversold levels. So you've got this big divergence, this bifurcation within the overall market. So it was kind of an interesting study just to go through all the sectors yesterday and look at those, just kind of how they all laid out. Because again, it's a very unusual bifurcation in the markets where you have about half the sectors very oversold, about half the sectors very overbought, and really nothing in between. So anyway, that article is on the website right now, realinvestmentadvice.com. All right, let's talk about what you need to know before the bell this morning. As I said, markets traded a little bit flat on Friday, didn't do a whole lot. Holding the 100-day moving average, we're going to challenge that this morning right out of the gate. So we're going to see if we can hold that 100-day. That 100-day moving average has been very important support, for a long time now. And again, we've been kind of coming down. We've tested it before, rallied off of it. We've tested it multiple times. That's okay, again, but we're watching this, and there's been this kind of deterioration in the momentum of the markets. You can see that in the momentum indicators as well. It's kind of this negative divergence of the markets where markets have been rising for the most part, but momentum continues to work off, relative strength continues to be weak, and that's because of that bifurcation in the markets that I was just talking about. But again, we're going to see if we can hold that 100-day moving averages today. If we fail there, then we're going to start getting down into some slower levels. We do have some support right around 66.50-ish, and then back down towards these lows, which are going to start kind of pulling us towards the 200-day moving average, which is going to be those lows that we had back in November during that sell-off. So then there is some support just below where we are. But we are starting to get into a little bit more dangerous territory. So again, just kind of continue to monitor your portfolio risk and how you're allocated right now. But again, this is what I was talking about earlier, is that when we look at the performance of the markets right now, so this is basically the S&P versus the equal weighted index. For a very long time, if we go back and look at this long-term scale, so the red line is the equal weighted index, the yellow line is the S&P 500. There's still, even today, over a longer term time frame, a very big gap between the market cap weighted index and the equal weighted index. However, over the last year, that performance gap, if we change the time frame, over the last 12 months, that performance gap has tightened up. In fact, they're about even right now. Both those indexes are up about 12%. But again, if we zoom in to just the last few months, there's this gap in performance as really shows itself. So again, over the last 6 months, the equal weighted index has outperformed the market cap. That's these other stocks in the portfolio. That's these sectors of the markets that are much smaller weights. And that's kind of the interesting thing here. You know, when you take a look at financials, you take a look at technology, which is about 30% of the index, you'd start talking about energy, utilities, industrials, basic materials. You combine all those together, those sectors of the market don't even exceed the market cap weighting of the technology sector, but they are the ones actually driving the markets right now. And that's okay, there's nothing wrong with that. But again, just want to be careful here because again, a lot of those sectors are getting grossly extended. So don't forget to take profits and rebalance your risk, because if you start getting a rally in technology stocks, which are oversold, that sheer weight and size of that sector is going to start to change this performance between equal weight and market cap weighted again. So again, just something to pay attention to. Look at that in your portfolio, but that's what you need to know before the bell this morning. All right, let me change gears here and we'll start with Jon Penn right after this.
The Real Investment Advice blog. It's required reading for the informed investor. Catch it today at realinvestmentadvice.com.
Say the word annuity and people cringe, but here's the truth. Annuities aren't the enemy of your retirement. Wall Street billionaires don't worry about running out of money. You do. What you're being told about annuities is wrong. Our next Candid Coffee will show you how the right annuities can reduce market risk, create lifetime income, and even replace bonds in today's volatile environment. Join Danny Ratliff and me for Candid Coffee, Saturday, February 21st. Before you dismiss annuities, get the facts and a plan built for your retirement reality. Candid Coffee, Saturday, February 21st. Register today at realinvestmentadvice.com. That's realinvestmentadvice.com.
You're listening to The Real Investment Show.
And welcome back to the show this morning. So again, last week we started talking about here on the show a bit about trust and kind of estate planning. And actually we were talking about something else and we kind of drifted into talking about trust. And we started getting a lot of questions and comments in chat, and then got a few emails following up on that as well. So again, we wanted to spend a little bit of time today, and we are working on a show with an actual estate attorney to bring them in as well, so we can even take some live questions and kind of a little bit deeper into detail. But today we get into kind of just the, talking about some of the different types of trust in particular, and kind of just talking about some general guidelines. As we were stating last week, most people overlook the importance of trust with their financial plan. Look, just stepping back for a moment. If you've got $100,000 in savings and you're investing in the markets, you probably don't need a trust right now. This is not really the conversation for that. However, if you're starting to accumulate some real wealth, or you're starting to get into, you're starting to build, multiple real estate properties, those type of things where you have multiple rental properties, or if you're starting to engage in other types of investment structures, private equity, etc. If you're to that level and you're starting to accumulate some real wealth that you need to make sure that is protected from lawsuits and liability, those type bankruptcies, those type of things, or you need to make sure that it's protected from estate taxes and legacy issues when you pass those dollars on to your children, then you need to really start thinking about the importance of a trust. And as we were talking about last week, this is kind of where things start to get a little bit complicated, because as individuals, we generally think about trust as that's end of life planning. I'm not ready to start talking about mortality yet, and I don't need to do estate planning. And so we put these things off, and unfortunately we put them off until generally it's too late, and then it becomes problematic for the family to deal with, because honestly, we're all going to die. Problem is we just don't know when, and we all think we're going to live forever. Problem is we don't. And so what you don't want to do is leave yourself in a position to where your financial estate is in turmoil because you didn't do some really easy kind of basic planning. And setting up trust are a very easy process. Yes, you're going to spend a little money with a trust attorney, but, and again, that's generally the first thing is people was like, oh, it's going to cost money, I don't want to do it. But you could wind up giving up way more in terms of estate tax. Just estate taxes alone can eat up 70% of your money. So just, you can give up way more without proper planning than the couple of $1,000s that you might spend building a simple trust. And again, I know it's like $2,000. Yeah, but it'll be worth it over time. And there's a lot of benefits to it as well. I mean, I have all of our investment assets, inside of a trust, and I run that trust as a business. I deduct my expenses against that business. And so it gives me tax deductions every year. So there's just things that you can do that more than offsets the minimal, very minimal cost of setting up a trust.
Yeah, I think I like to watch the bottom line on a lot of things when it comes to spending, but there are things out there that you shouldn't skimp on. Mm-hmm. And I think that's your estate plan.
Speedos and estate plans.
Speedos and estate plans.
Never skimp on a Speedo.
Wow, I was not expecting that one.
Well, Italy's
but that is true.
Italy's coming up soon. So.
Yeah, that's true. Okay, very good. But skimping, don't skimp on your Speedos or on your estate plan either, right? And sometimes I find too, as folks are starting to build their estate plan, they want to build the perfect estate plan from day one, and sometimes I see where it's almost overanalysis causes some paralysis, and we never even get an estate plan in place, period. Because I think we're trying to build the perfect estate plan. Look, just get started, and like Lance said, maybe you're just starting out, maybe a will and your basic estate planning documents, your durable powers of attorney, medical powers of attorney, your advanced living directive. Get your start, but then as you get older, you start accumulating more wealth. Then it might make sense to start exploring some trusts. And then as your kids are, so an estate plan, in my opinion, is something that could be revisited every 5 to 7 to 10 years, because as your lives change and evolve, so will your estate planning needs. But sometimes I think we want to get the perfect estate plan in place, and then I have that conversation with a couple. I'm like, tell me about what estate planning you've done. And they look at me with these big eyes. They're like, well, we've been trying to do this for 20 years, but we haven't got anything in place. Just get something in place, get the basics in place. So if you're just getting started, a will can work just fine. But then we get into the world of trust, and there's kind of two main categories. You have revocable trusts or irrevocable trusts, right? And quite simply, a revocable trust is a trust that can be changed during the course of somebody's lifetime, right? And
the kid's out.
The kid's out,
in,
right?
Kid's out, yeah.
So, and we see, especially in states where the cost of probating an estate is very expensive, like California, right? I see a lot of revocable living trusts used instead of a will, because the revocable living trust, when the trust owner, when they pass away, the assets will pass by the terms of the trust and bypass probate altogether.
Right. Stop right there. I want to back up 1 second, because you brought up a will, which is a very important part.
Yeah.
Also, part of what we're talking about here goes into how you set up your accounts as well.
Yes.
And this is very important. So if you have a basic will, that's a great start, right? And if you're going to do a basic will, I would at least do some medical powers of attorney as well to make sure that your wife has the ability to pull the plug on you if needed. But you need to set up your accounts to follow along with the will. So for instance, in your will, it says that my will that my wife gets 50% and my 4 kids divide the other, I'm just making stuff up, but divide the other 50% up between the 4 of them. Well, I need to make sure that my account structure is also set up to comply with that. Because if I just do, a joint tenants with rights of survivorship, or just a kind of a joints in common kind of account, it can bypass the will if it's not set up properly. So it's also important that the account setup process needs to comply with your estate and will structure.
Well, so you're spot on. So in addition to brokerage accounts, any type of account structure where you can designate a beneficiary, IRA, company 401k plan, 403b, annuities, life insurance policies, anything where even a regular brokerage account, like at Fidelity, Schwab, Vanguard, E-Trade, on that, you could have a brokerage account that's in your individual name, but then you can add a beneficiary to it. So that way when I pass away, those assets will bypass probate altogether and go directly to the beneficiary, just like joint tenant with rights of survivorship. Right. If, like with my wife and I, if we are a joint account holder and I pass away, she is the surviving spouse, those assets automatically go to her, just like IRA assets. So all of that will supersede what you have in your will. So if your will lays out, hey, I want this, like if I say in my will, I want the assets to go to Lance, but on my IRA, my wife is the beneficiary, she's getting the assets, right? So you have to make sure that your beneficiary designations are aligned with your will.
Because if you don't set it up right, I mean, it gets messy. You got to hire hitmen and all kinds of stuff. It just gets very.
You don't want to get Guido out of the back with a pipe, any of that stuff.
But it was actually, I was just reading an article over the weekend. A guy had so in this story, it was talking about this kind of same thing about setting up accounts structured properly. So this gentleman, he was 65 years old. He had about $700,000 in his investment accounts, and he wanted to make sure that his daughter was taken care of and everything, just in case he passed away. So he added her as a signatory to the account. Now, instead of putting the assets in a will or into a trust that would have protected it, his daughter, unfortunately, got into an accident and injured somebody. She got sued. And when she got sued, they went right through her into that account because she owned the assets in the account, because she was a co-signatory on the account. And so just by adding her as a signatory, he transferred ownership of those assets to her, which then made it available for that lawsuit. And so now his assets are gone. So, but again, that could have been avoided simply by setting up a very basic trust saying, look, upon my death, these assets are yours. But then when she went and got into the accident, that trust would have been separated out from the liability and would not have been involved in the lawsuit.
Yeah, agree. So, and you mentioned a great point earlier about your powers of attorney, your durable power of attorney, your medical power of attorney. So whether you have a trust or if you have a will, you're still going to need what are called those ancillary estate planning documents. That's a whole other set of documents: durable power of attorney, medical power of attorney, your advanced living directive, your HIPAA release. So, and typically when you put a will together or you put a trust together, those documents should kind of come as a package.
They do.
So just make sure that
and if you sit down with a good estate attorney, they're going to draft the whole package for you.
Absolutely.
And don't dismiss that either. My wife got cancer, and so when we had to go in to have the surgery to remove the cancer, they were like, well, you have medical powers of attorney. If not, we have a document for you, which is a very basic document. Now, fortunately, we had full medical powers of attorney already set up. We already had the HIPAA releases, so we just supplied the documents to the hospital. Everything's fine. But don't overlook, especially when it becomes to more serious surgeries as you get later on in life, unfortunately, cancer surgeries, whatever they are, where there's a potential for a loss of life, those medical documents become much more important to have.
Yeah, and from a very high level, there are many types of powers of attorney. There's limited power of attorney, there's full power of attorney, then there's durable power of attorney. And especially in the world of estate planning, the durable is so key, because if my wife Shauna is my full power of attorney and I'm out here driving on I-10 coming to the office and I get in an auto accident, I'm still alive, but I'm incapacitated. Right. If she is my full power of attorney, that full power of attorney upon my incapacitation becomes null and void. So she needs to have what is called a durable power of attorney, because even though I'm incapacitated, that durable still allows that power of attorney to stay in place. So just a reminder for folks listening, if you have those powers of attorney in place, just it always makes sense to just double check it, make sure it's durable, and just just little things like that, just make sure you got everything in a row. You hope you never need to use these documents. You hope you never need to use them, but they're there. They're there in case you do. No, all great points. So we were
I got off because
No, that's
you were
fine.
talking about a will, and then we were starting to get into the revocable and irrevocable trust.
Absolutely. And just, again, from a high level, there are kind of who are the parties involved in a trust. You have a grantor, and that's the person who creates the trust and will actually place assets into the trust, and the grantor will actually set up the rules for the trust, and it's the trustee that actually manages the operations of the trust. Then the beneficiary is who are the assets for, like who can use the assets in the trust. So I just want to mention that grantor, trustee, and beneficiary. But yes, so from a high level, Lance, in the world of trust, you kind of have two main categories. You have revocable, and basically that just means that the trust can be changed during the lifetime of the trust owner. Right. And again, I see a very common revocable trust that's used is what is called a revocable living trust, and that is used instead of a will, because if assets, if somebody uses a will, their assets you have to go through the probate process, and certain states are pretty expensive. Texas, compared to many states, Texas is pretty reasonable from a probate cost standpoint. California is, sorry to pick on California, very expensive. So I see a lot of revocable living trusts used in California, but you have to watch out for with a revocable living trust. It's really just used to bypass probate, and it keeps the transfer of assets, that process, it keeps it private, because if you use a will and go through the probate process, after that's done, all of your assets, your estate, that all becomes public record. So revocable living trust can be used to keep your affairs private. But I think sometimes there's a misconception about revocable living trust that they're going to provide creditor protection. They do not, because the revocable living trust. I am typically the grantor, the trustee, and the beneficiary. It's all set up under my Social Security number. So the creditor protection, or the protection from lawsuits, or protection from divorce, or what have you, that's really where the irrevocable trust comes into place. And that's a trust that once it is set, it is set. It cannot be easily changed once established. And if I am the grantor, if I am putting some of my assets into an irrevocable trust or irrevocable trust, I'm getting those assets out of my estate. And at that point, creditors cannot, if for some reason, if I get into a situation where I'm at risk of having creditors come after me or getting sued, now those assets are in this irrevocable trust. Those are now, because it's its own entity with its own tax identification number, that is now out of my estate. So now those assets are not at risk. Right? So that's where trust planning for asset protection, wealth transfer strategies, that's really where an irrevocable trust, that's really where that comes into place. Right.
So this brings up a few things too. And again, this is once you start setting the trust up, that's one thing. And then there's another section of this that you're going to sit down with the attorney and they're like, okay, well, so tell me what you want. Right? Because the trust can be anything you want. It can. And I was watching a show the other day, and the guy has 3 daughters, and the daughters didn't get along well. He was very wealthy. He was a rich hedge fund manager, right? And he passes away. He leaves a video, and in the video he hides all the assets, and basically they've got to solve a treasure map to go get this, right? So that was all in his trust. And so the point is when you sit down with the attorney, you need to go into the meeting a little bit well prepared, right? So that way you're not wasting the attorney's time, you're not wasting your time and running up more billable hours. So I encourage you to sit down with your wife and say, and y'all get on the same page before you go talk to the attorney. Don't start debating this with the attorney, because it's just going to run up the billable hours. So have a good idea of how you want the trust structured going in, right? So at what ages, so let's say you've got 2 kids, right? So at what ages do you want the assets to transfer in full to the children? You want that to happen immediately upon death? They get all the assets? Do they get them at a third at 25, a third at 35, a third at 45? However you want to structure it, that's up to you. But this is where you need to do a little bit of conversation ahead of time, just with your wife at least, or your husband, depending on which one of you is talking to who. But kind of have a general understanding between the two of you about what are the parameters. So let me give you a good example. I'll just tell you how my trust is set up as an example. So when my wife and when I pass away, all the assets move to my wife, so she can continue to live her life until she passes away, or vice versa. But when we're both passed away, the assets move into a structure that my children will have access to, and they all have access equally to on an equal pro rata basis, 25% each, to the funds. However, they cannot get to the funds unless they have a college education, are gainfully employed, and have a job, right? That's the first 2 criteria. So they have to be working, producing citizens of society. When they start getting assets drawing out of it, they decide to quit their job and go live on a beach, the trust cuts them off, because they need to be productive, assets to society, not just living on it. You hear about trust fund babies. We're not going to have that, right? Our kids are going to be productive. So they've got to have a college education, or military background, either two. They're all going to college, so that's not an issue. And they have to be productive members of society. Now, once they get to that level, they can start getting access to the funds in the trust. However, they can never touch the principal of the trust. The trust is there to not only feed our children, but our children's children and our children's grandchildren, and so forth and so on. So we're creating a legacy for our family going forward. And so they can withdraw up to 1% each of the income, because there's a 4% withdrawal rate on the trust every year, and they can each take 1% of the trust income out a year to supplement their income. Again, the job of the trust is not to make them independently wealthy. The purpose of the trust is to make sure they have a living income stream to help support them. If they want to save up the money and go buy a house, whatever they can do whatever they want, but they can never touch the principal. They can only touch the income that comes off of the trust over time. So that's just kind of, but my wife and I spent a lot of time debating over this back and forth to come to that, and then when we sat down with the estate attorney, we laid out those rules. But however you want to do it is simply up to you. The one thing I encourage, though, is that from 35 years of doing this, I've seen three things happen with trust. The first thing is that when the parents pass away, the money transfers almost immediately to the kid. And for instance, I had a client, they both passed away in a car crash. They had one daughter. She was 19 years old. They transferred $2 million to her immediately upon her death, because that's the way they structured their trust. So she had full access to the trust. The entire $2 million was gone in 2 years, because she got involved with a boy. He literally bought a worm farm to raise worms.
Sounds like something from Christmas Vacation.
Exactly, and but literally this, and then they were buying expensive cars and boats and a big house and all this. And well, in 2 years, the money's gone. All the taxes, everything came along with it. So again, you have to think about the financial responsibility of your children when they're going to receive this money. I know personally at 25, I was not financially responsible. At 35, I was not financially responsible. At 45, I started getting my act together. And at 55, I became financially responsible. But that's most people, right? I mean, it takes us time. We have to go make our financial mistakes. We've got to run up our credit card debt. We've got to do all that stuff and learn from those mistakes. So think about how financially responsible your children are, and say, if I gave them a bunch of money at this particular age, 25, 35, 45, whatever, how are they going to be handling that money? Are they going to be responsible with it so that it'll support them for the rest of life? Or are they just going to go spend it and do stupid stuff? So, but those are things, your kids, and those are things that you need to think about.
Yeah, no, all great points. And in the chat, so R. Schmidt, I hope I'm pronouncing this right, 9699, asks the question, do beneficiary directions at a broker override a will? Yes, they do. again, any IRA, traditional IRA, Roth IRA, SEP IRA, simple IRA, anything that has a beneficiary designation on it, that will override or supersede what you put in a will. Great question.
Yeah. And look, wills are very basic, and they're fine for their purpose. And if you've just got cash sitting in a bank account somewhere, the will work. It'll be fine. But anything, this is what we're talking about, how you designate your account, joint tenants in common versus joint tenants with rights of survivorship. That can have a big impact on how the assets are distributed out of your will. So you need to make sure that if you're just going to have a basic will, which is okay, just make sure that, again, like John was talking about, if you've got an IRA, you need to make sure the beneficiary on the IRA is the same person you want to have the money inside the will.
Absolutely. And you were talking a little bit about having a game plan before you even go visit with an estate attorney. So what I like to do is I'm working with individuals and families is have conversations like this where we just talk about what are the different types of estate planning tools out there in the tool shed that somebody might be able to use, and what are the pros and cons of each. And again, there's not a right or wrong way to do this. At the end of the day, you have to structure your estate plan based upon your own situation and what's right for you. But what I find that's helpful is there's a template that I have that I like to send out to clients that kind of gets your gears turning a little bit, and it starts asking you some questions where you can sit down with your significant other. And again, these are always really fun conversations to have, but you can sit down with your significant other and just go through this little template, because it's designed, again, to get your wheels turning, because it's going to ask you, who do you want to be responsible for carrying out the wishes in your will? Like, who do you want to use as your executory or executrix? But then, if we were talking about powers of attorney earlier, those durable powers of attorney, those medical powers of attorney, here's what you need to think about as well, because heaven forbid, if I predecease my wife, if I predecease Shauna, and then later down the road, she becomes incapacitated at a later point in time, well, who else can now step into that role and take care of those responsibilities since I'm no longer around? Like, who's back here in the batter's box? You got to think about that, right? So if you're going to use a trust, who would you want to use as a trustee? Or if something happens to your initial trustee, do you have a secondary or even a tertiary trustee in mind? So it's
and that gets really important.
Yes, it does. Go ahead.
I was going to say, because this was the challenge my wife and I went through. It's like, okay, we're older, right? We're getting older in life, so all of our friends are the same age as us. And so you start thinking about, okay, well, who is going to be our trustee? Well, immediately you go to somebody that is close to you that you trust very much. The problem is that they're the same age as or older than you, right? So how long are they going to be around? So if I die tomorrow, they're great, but if I live another 20 or 30 years, they may or may not be here. So you have to start kind of thinking about, okay, who's going to be the trustee? So again, your first trustee should obviously be somebody you trust without question, right? So just, it could be a child, it could be, a family friend, it could be anybody. You can literally name anybody to be your trustee. You need to have a backup to that person. And I would probably choose somebody a little bit younger that will probably be around a little bit longer. But again, so if the first one passes away or something happens, you've got a secondary. Your third trustee needs to be an institution that's going to be here forever, because your first two trustees are going to pass away eventually. I mean, everybody's going to die at some point. And so you're going to go down to that third level at some point, whether it's this generation or the next generation or the generation after that, whatever it is, you need to have that third trustee being an institution, somebody like Northern Trust or U.S. Trust, somebody like this. So there are these very big trust companies that are out there. This is all they do, is they just manage trust. But you can define, you define in the trust how the assets are to be managed, what are they to be invested in, what investments can be made, what investments can't be made. I don't want my trust ever invested in private equity. I'm just making that up, but you could say that. Ben Franklin, his trust could only be invested in bonds, right? So it could never be anything other than bonds, and so that was just it. But the reason for that trustee is that trustee will be there over generations, and you just give them a very detailed list of how the assets are to be managed. They have to follow those predetermined rules, right? So they can't go off and just do random stuff that they want to do, buy you high fee products, whatever. You can specify how you want the assets managed, but it needs to be a trust company at that point that will pass through your legacy. And this is why companies like Northern Trust and US Trust, they've been around forever, and that's what they do.
Yeah, and this becomes a real challenge for a lot of folks out there, especially if maybe you're a married couple and you don't have children. Like who would step in to be your secondary, like who would be your trustee, or if I pass away, who would be a contingent trustee or a tertiary trustee? I mean, there are a lot of couples out there that either they don't have children or they are very displaced from their siblings. Like there are many clients that I work with where families on one side of the U.S. and we're over here on the West Coast, and heaven forbid if something happens to them, they have a trust in place, but they don't have a lot of folks that they trust to actually be a trustee on those assets. So then that's when they have to start looking at like some sort of a corporate trustee structure. And then it's about, well, then who do they use? Who do you trust? And what I find that folks run into is that sometimes those trust companies, and most of the time it's, especially something you have to be careful with banks a little bit. Their fees tend to be a little bit higher, right? And most of the time I see that I think folks want to have more say in what investment options are used in the trust, but sometimes the challenge that they run into with certain banks is that it's just a lot of in-house proprietary investments, and there's not a lot of flexibility there. Right.
And this one, you need to do your research,
Yes.
right? And you need to, pick a trust, trust company that you really, and don't worry about meeting with the person, right? That person's not going to be there, right? So it's really just, finding out what your options are for investments and how you define them. So again, like John's point, you might want to not consider just examples. I'm not saying anything in particular, but J.P. Morgan has a lot of proprietary assets. So maybe you decide not to use J.P. Morgan as your trust company because you're worried that they're just going to invest in all their proprietary assets. With Charles Schwab, same way. Schwab has a ton of proprietary products, and they tend to invest you, if you do their smart portfolios or whatever, they tend to be all invested in Schwab products. So you may want to find a company that has the flexibility to invest in kind of anything you want. But again, not so much the person, because that person is probably not going to be there. Find out what the structure of the trust company is that's going to be managing the assets and what flexibility they have.
Yeah,
and what fees they charge. Those type of things.
And what fees they charge. But when there is a need, you want to find out who is your dedicated person that you do reach out to at the trust company, right? And now I am finding that there's quite a bit of so you mentioned Schwab. So there's brokerage firms. They now have their own trust departments, teams. Schwab, Fidelity, and now they allow you to somewhat bifurcate the roles and responsibilities. So in other words, Fidelity could be the corporate trustee. They handle the administration of the trust. They handle preparing the tax return of the trust. But then if you could hire a registered investment advisory firm to actually manage the assets in the trust. So the roles are a little bit bifurcated. Fidelity or Schwab, they're the corporate trustee handling the day-to-day administrative duties of the trust. But then the advisor, that third party, they can run the investment strategy based upon the goals and objectives of the trust for the trust beneficiaries. And I typically see there's a lot more flexibility with investment portfolio and management through that option. Not saying that's the right option. At the end of the day, you have to do your homework and find out what's the best option for you. But I find that to be a real big challenge for folks who maybe they don't have children or they don't have family members in their immediate area, where they just they don't want to rely on a neighbor to have this done. This comes up more often than not.
Oh yeah, absolutely. And again, because there needs to be some level of a durability, survivability, right? But also a level of expertise as well.
Absolutely. So we were just hitting the irrevocable trust again, when we were talking about revocable versus irrevocable, some reasons to use or consider using an irrevocable trust is once assets go in there, now you're really looking at protecting your assets from creditors and lawsuits. I see a lot of folks that are in a position where they are very open to maybe having lawsuits go after them. Physicians, business owners, just wealth preservation planning in particular. But then just getting money out of an estate for estate planning purposes. I mean, right now the estate tax exemption per person is $15 million per person. So for a married couple, that's $30 million. So before you're going to have any sort of estate tax, you would need to be over that. If you're a married couple, you need to be over $30 million. But sometimes, so if you're in that position, an irrevocable trust could be used. You place assets in that irrevocable trust structure that gets money out of your estate. It can help you protect estate taxes. And there are many different types of flavors of irrevocable trusts. And maybe perhaps like when I have that interview with the estate planning attorney, we can get into that. But there's a whole world of different irrevocable trusts out there that you can look at. Another talking about irrevocable trusts, if you're concerned about divorce, like I said, our children, our oldest daughter is now engaged.
Yep. I was going to get to this because this is a super important point.
Go for it.
Well, no. I mean, this is the. I think this is probably the most important aspect of a trust.
Yeah.
Without a doubt.
Yep.
And this and the one reason and this was I don't really care when I die. I'm looking to be dirt food sooner than later. So, but the big concern is children and them getting married. So here's a problem. You have let's say that you've got $500,000 saved up in all your various investment accounts, etc. And you, through your will, you pass them to your children. And so let's just keep things simple. You've got a daughter and she gets married to somebody. And so you've passed the assets onto her. She now has the assets. She gets married and then they live in the state of Texas, as an example, and they get divorced. You have nearly a 60% divorce rate in the US now. So divorce is a very high probability.
Yeah.
Half those assets will go to the spouse on the divorce. So half of everything you've saved up for over your life that you wanted your daughter to have is now lost through the divorce. And so this is where I just had this conversation maybe 2 days ago about this very topic. Setting up trust, because once the trust is set up, that becomes her property. And when they get married, this is where I think we were talking about a prenup.
Yes.
Recently as well. Mm-hmm. This is where the prenup becomes very important because it then separates out that. So first of all, the trust is her asset. So even in divorce, the divorcing partner cannot get access to that trust because those assets are in that trust, in that structure for her. So they can't get access to it unless she violates the trust and commingles assets. So there are some rules around this that they can never commingle assets into the trust. But the other side of that, though, is that this protects those assets against divorce and all kinds of other issues. If she gets, again, we're talking about the issue where the daughter gets into a DUI accident and gets sued. That trust is protected from those type of lawsuits and things as well. So it's extremely important to preserve the legacy of the assets and keep them in the family. The trust is extremely important.
Absolutely. And Pistol Pete in your chat, you bring up a great point. So there are online platforms that you can use if you just don't want to use or go visit with an estate attorney. So online estate planning platforms. This is not a promotion or this is not an advertisement, but LegalZoom and Trust and Will are two online applications that are very good. Those are worthwhile to explore. But if you find that you have, properties in different states, and you have just a number of different, if you've built up significant assets, and let's say you've got rental properties in many different estates, I think it makes sense to visit with an estate planning attorney. You're going to pay a little bit more, but at the same time you've got a lot more moving parts, a little bit more complexity. I think it makes sense to sit down and and actually visit with somebody to get this done.
Look, we had a link on our website for a long time for Trust and Will. Good company, nothing wrong with them. But all it takes is one loophole.
Yeah.
One piece of property, something that you didn't specify properly in that document, it's worth the extra money that you will spend to get with an estate attorney and go through this step by step. Because again, once that's bulletproof, then the assets are going to be protected. As long as you just have to follow the rules. We're talking about getting when children get married, if they bring assets into that marriage, they need to designate those assets as a separate property account. And you can actually title the account separate property of John Penn. Those are my assets before I got married. And that can also help protect somewhat in the event of divorce, as long as you don't commingle assets.
Absolutely, and that's a key point. So when you create a trust, make sure you actually title your assets in the name of the trust.
Yeah. That's a very big point.
Because you can have a trust, this is great, you've got your trust document, but you actually need to follow through and whatever assets need to be titled in the name of the trust. Otherwise, all this is just a piece of paper that you paid a lot of money for. Right? So you actually need to follow through. And I have found that typically when folks work with an estate attorney, they're more compliant about getting that done. Right? No, great points. Had another listener. They asked us to talk a little bit about trust protectors. So just wanted to mention something about that. So a trust protector it's an independent person or could be an entity that you appoint or give somebody the right to oversee the trustee and protect the interest of the beneficiary. So it's like another layer of protection where the protector acts like a safeguard. Where, especially for irrevocable trust, I've been saying irrevocable and irrevocable, tomato, however you want to do it. But especially for irrevocable trust, so the trust protector is there to oversee the trustee, and if the trustee isn't acting in line with your goals, whether if it's portfolio management or just how the trust is being administered, the trust protector can basically help to change the trustee, right? So that's just an extra layer of protection that you can put in your trust. I would just say if you're going to look at exploring a trust protector, it's great to have that in the trust initially, but if for some, I have seen times where a trust protector is added after the trust has already been created. So just wanted to mention that. Yeah. So a trust protector can also be a very useful tool when it comes to trust planning, just to make sure that whenever you set up this trust that it's being managed appropriately.
Yeah. And there's a few comments about how much does it cost to set up a trust. When I set mine up, they were about $7,000. This was a few years ago. We're about to do a full update of all of our trust documents and a rewrite since my wife's diagnosis. So some things have changed. So we're going to redo that. And right now our quotes are coming in between about $7,500 and $8,000. So again, it depends on, it's going to depend on what state you live in. It's going to depend on which law. I mean, if you use a big, white shoe law firm, that's going to cost you more than, a one-person estate planner, down the street somewhere. And again, one's not necessarily better than the other. I'm just saying you're going to pay, depend on who you hire, is also going to affect the cost.
Yeah.
I mean, these aren't like off-the-shelf things. So it also depends on how detailed you are, how many moving parts you have. If you've got a bunch of real estate properties and you've got to go set up a bunch of LLCs, that's going to increase your cost somewhat. So, but again, if you spend let's say you spend $10,000 setting up your trust properly, and let's just say you've got $1 million of investable assets that are all inside this trust. Is $10,000 that expensive when you're looking at potentially up to $6 to $7 million in estate taxes and probate taxes and everything else that could occur or the loss of half the account to a spouse that gets divorced with your children. I mean, what are the costs? 10 grand may sound like a lot today, but just put that into perspective of what the losses could be if the account wasn't set up properly in the future.
Absolutely. I'm fortunate to work with a number of folks all across the country, and I've seen hourly rates for trust and estate planning range anywhere from $350 an hour up to $1,000 an hour. It just depends on where you're located, what state do you live in, how complex are the laws of that state, and how complex is your own estate plan that you're putting together. So it's really going to vary from one state to the next.
Right. And I said 6 to 7 million. I'm at 600,000 to 700,000. But you get the point.
Yeah.
You got the math. It can be expensive. And again, but these are real simple things to fix and real easy things to do. And I think too many people they postpone it, they overlook it, and they're like, oh, I'll get to it later. I'll get around to it, because you don't want to deal with mortality. My wife is very difficult to work with on this because she just doesn't want to think about me passing away.
Yeah.
And having to go through that, because you have to sit down and talk about, okay, when I'm gone, this is what's going to happen. And she doesn't like facing that reality, right? But it's just a reality that's going to happen to all of us. And so it's important to kind of buck up and go down and get it done sooner than later, and you'll be grateful you did.
Yeah, it's a very emotional process. And usually it's not uncommon with a married couple that one is a little bit more willing to get into this than the other. So I find myself sometimes being a counselor between the two, but in a way this is something that needs to be done, because I think at the end of the day, just as investors, we all get so wrapped up in, well, should we be buying Microsoft, or should we buy Alphabet, or should we take some profits in NVIDIA? And the portfolio management side, I mean, that is all crucially important. But what Lance and I have been getting in today is an even bigger area of risk management, and that's protecting yourself and your family and your loved ones, and protecting your estate, and true risk management of your assets long term. And it isn't fun to sit down and think about your own demise or one passing away. And we hope that we're all blessed with a very long runway of time, right? But it's good to sit down and have this in place. So I find myself as an advisor, as a fiduciary, part of my role is to be pleasantly persistent, and I am constantly reminding clients to eat their vegetables. And part of that is, hey, we were talking about your estate planning last year in 2025. Have you gotten that done yet? Have you made the appointment with the estate attorney? Have you looked at LegalZoom, or have you looked at Trusted Will? Whatever mode or whatever route you're taking to get your estate planning done, it's, hey, have you done this yet? And sometimes they hear, John, no. I'm going to look, we're going to make 2026. So this is going to be the year we're going to get this done. And we're going to buckle down and we're going to do it. And it's after it's done, it never fails. After the estate planning documents are in place, everything is signed, I usually see this sigh of relief, because it is a process, and it is emotional, right?
But you just knock it out and get it done.
That's it. Get it done.
It's like, going to the doctor. Just go get it done.
Go get your teeth cleaned. I know. It's not fun, but you got to go do it.
Just one last question, and this is a good question, is does it require a court order to change a trust company?
I don't know.
It depends, right? So, and again, I don't know the exact answer to this, and a lot of this will depend on states as well, each individual state. As long as you're still alive, you can change trust. You just have to update your trust document and change the trust company. Once you pass away, that trust company then takes over those assets. It does become a bit more onerous on the trustees to change the trust company, because the trust document is what runs, and you specifically named in that trust document, you said U.S. Trust is the trust company, as an example. It does become a bit more challenging to change that. I don't know all the legal ins and outs. It's a good question. When we talk to the estate attorney, we can ask that question.
Usually the ability to change a trustee, whether if it's an individual or an entity, that is language that would actually be included in the trust, where there's the right to change a trustee. So I would think, as long as that language is in the trust document itself, you shouldn't need a court order or some extra go through you shouldn't need a court order to do that.
Well, again, this is why it's
But
important.
it's got to be. But I would think it's got to be important to have that language as part of the trust document.
Exactly.
From day one.
Right. No, exactly. And that's what I'm saying. Is like as long as you're alive, it's easy to change stuff. Right. You just rewrite the document. That's no big deal. Once you pass away, it does become more onerous. And again, and this is why it's important to make sure that you've got language in there. If you want to allow your children to change trust companies, those type of things, make sure that language is in there.
Correct.
So,
Correct.
All right, that wraps up the show for today. Hope this was helpful. We will get that interview set up with an estate attorney here one Tuesday coming up with Jon Penn to basically, have you can ask questions, live of the estate attorney right here through chat. We'll get into all those as well. So we're working on setting that up now. I don't know when we're going to get that done, but we're working on that process. So hopefully sooner than later. But in the meantime, if you have any questions, get by the website, send us questions, comments through our email. Just ask a question button. I'll get those over to John. We can get those answered for you. And again, if you have any other questions at all, be sure to get by the website as well. Our latest article is out on the website right now, realinvestmentadvice.com. Be sure to like and subscribe to the channel. If you like today's show, give us that thumbs up. We certainly appreciate it. And we'll see you back here tomorrow for live Q&A. We'll do live Q&A tomorrow right here with Danny Ratliff on the Real Investment Show tomorrow. See you then.